I'm Laura Preston. I'm a student at Ashford University in our Health Care Ethics and Medical Law class. I'm a juror in the case of Denise F. versus Ashford Hospital. Ms. Denise F. is suing Ashford for the improper release of her health information protected under the privacy rule. The plaintiff is an employee of the hospital and at a given time was also a patient there. She was in need of a surgical procedure and Ashford Hospital distributed an operating room schedule to employees via email. The information contained the plaintiff's surgery as well as her date of birth, her social security number, her place of residence, insurance information, previous surgeries, past medical conditions, former and current medications she is taking, the name of her primary care physician, the name of her psychiatrist, and other health professionals she has seen throughout the past year. Her supervisor is not a part of her medical treatment team. She is not a part of the OR team, but she is a senior administrative position within the facility and as such was given a copy of the OR schedule as well. The plaintiff maintains that she did not give permission either verbally or written to anyone on her treatment team, surgical team, or her primary care team to release her protected information, her address, date of birth, insurance information, the name of her psychiatrist, or other non-related information to her current scheduled surgical procedure to her supervisor, who had no connection whatsoever to her treatment as a patient at that hospital. The defendant, Ashford Hospital, maintains their actions in emailing this information to the OR staff as well as her supervisor was justified as a need-to-know basis to properly treat and administer to this patient. My decision as a juror in this trial is I find in favor of the plaintiff on the following legal grounds. It is the requirement of the privacy rule to protect the patient's identifiable information at all times. This includes identifiable demographic and other information relating to the past, present, or future physical or mental health or condition of an individual, or the provision or payment of health care to an individual that is created or received by health care providers, health plan, employer, or health care clearinghouses. Anyone who is involved in patient care is obligated to this privacy rule. HIPAA seeks to balance protecting the privacy of patients' health information and ensuring that this information is available to those who need it to provide health care, payment care, and for other important purposes. The Office of Civil Rights specifies that a central aspect of the privacy rule is the principle of minimum necessary use and disclosure. A covered entity, such as a medical facility, and their staff must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information needed to accomplish the intended purpose of the use, disclosure, or request. In other words, you don't have a need to know it, you don't need to know it. Okay? If an OR team is performing surgery, they don't need to know the name of a psychiatrist unless the patient is suicidal and they shouldn't be operating on them in the first place. They don't need to know her insurance information because they're not going to make sure a bill is paid. It's not their job. Okay? So what you need to understand is that there is no legal requirement for anyone to have this information without the patient's written consent. Okay? The defendant has not shown justifiable cause by any law or regulation that would allow for the disclosure of this information to the plaintiff's supervisor at her place of employment. Regardless that the place of employment is also her medical provider, the plaintiff is entitled to all the rights and protections she would incur had her provider for medical care not also have been her place of employment. The control of electronically held information is afforded the same protection as paper files would have, which means that the security has to be equal, if not better. The security section of HIPAA provides for a technical security services component regulating the safety and security of stored data on the network. A technical securities mechanism component addressing how protected health information is transmitted by encryption over a communication network such as the internet. Means they have to be really careful because emails are part of this technology. The Office for Civil Rights specifies that a central aspect of the privacy rule is the principle of minimum necessary use and disclosure. A covered entity, such as the medical facility and their staff, must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information needed to accomplish the intended purpose of the use, disclosure, or request. It grants authorization to give this information out, but only by written or verbal authority of the patient or the patient's authorized provider, personal representative, Technology has its place in the medical arena, as does the notion that a patient has the right to be protected at all costs from personal medical and demographic information being emailed to anyone, even an OR staff, and certainly never to a supervisor who has absolutely no reason to have this information. What is necessary for an OR staff to know to treat the patient is current medications and surgical procedures done in the last year. What is not information the staff needs to know is her place of residence, her insurance information, and the fact that she has a psychiatrist. If the hospital can produce a medical necessity or legal reason for this information to be available to the OR staff and the plaintiff's supervisor, this case would not have come to court, let alone a jury. The hospital has a fiduciary obligation to protect the private health information that their patients and of their patients and employees as well. That's my decision. Thank you very much. Okay, now come on. I gotta turn this off now.